Oyez, oyez, oyez. The Supreme Court of the United States is now in session. The Honorable Chief Justice Bach presiding. All those having cause to be before this honorable court draw nigh and pay heed. God save the United States, and God save this honorable court.
Good evening. We'll hear arguments this evening in case number 26-533, David Bronner, President of the United States, Petitioner versus Mark Crosby, the Respondent. Is the petitioner ready to proceed?
The petitioner is ready, Your Honor.
Great. Is the Respondent ready to proceed?
Yes, Your Honor, the respondent is ready.
Great. The petitioner may proceed.
Thank you, Your Honor. Mr. Chief Justice, Honorable Associate Justices, and may it please the Court. My name is Caleb McClure. My co-counsel Xander Yoder and I represent President David Bronner, the petitioner in the case at bar. At this time, I would like to reserve 3 minutes for rebuttal.
That's granted.
Thank you, Your Honor. My co-counsel will address the issue of remedy, but first I will address the Article 2 issue. At stake in this case is how we hear the will of the people. The court in Sela explained, the constitutional strategy is straightforward. Divide power everywhere, except for the presidency, and render the president directly accountable to the people through regular elections. How this court understands the president's Article 2 powers directly determines how heard the people's voice is. In order to represent the will of the people, the president must be the master of his own house. We offer 2 lines of argumentation. First, the 2 recognized exceptions to Article 2 removal powers do not apply. And second, no exception for a central bank like the Federal Reserve either exists or should exist. It's because there are no applicable exceptions, therefore, that we ask this court to overturn. Turning to the first line of argumentation, and beginning with the first recognized exception to the president's removal power, that being Humphrey's executor of the United States. In Humphrey's executor, this court upheld calls for removal protections for the Federal Trade Commission, or FTC. However, this case is fundamentally distinct from Humphrey's executor, and as such, this exception does not apply. Firstly, Sela confined that case to its facts, noting that Humphreys put special emphasis on the particular officers of the Federal Trade Commission. The court in Sela said, because the court limited its holding to officers of the kind here under consideration, the contours of the Humphreys executor exception depend upon the characteristics of the agency before the court, and rightly or wrongly, the court viewed the FTC as it existed in 1935 as exercising no part of the executive power. And that leads to the second.
Counsel, you don't think that the Fed exercises exclusively executive power, do you?
We would not disagree with that assertion, Your Honor, but we would point out that it is, in fact, primarily executive, and while certain aspects of how it can use its executive power can appear as quasi-legislative or quasi-judicial, Arlington v. FCC, as subcited in Sela, explains that even though the activities of administrative agencies take legislative and judicial forms, they are exercises of, indeed under our constitutional structure, they must be exercises of the executive power.
So is your
Honor?
position that Humphrey's executor, that the commissioners on the FTC and Humphrey's executor were in fact not exercising any executive power?
We don't believe so, Your Honor. In fact, we would classify the Federal Trade Commission as wielding substantial executive power, which is why we would acknowledge and agree with the idea that Humphrey's executor is at this point improper law and could be overturned. However, we don't believe it's integral to the argument that we make here today, as the court in Sela already explained that at the very least that case is limited to its facts, and we understand that, Your Honor? Then we understand clearly that
Should
as that
we,
case is...
so
Your Honor.
counsel, just so I understand your argument, should we overturn Humphreys? And if so, why or why not?
Your Honor, we don't believe overturning Humphreys is necessary for the instant case or for our contention. However, the reason we believe Humphrey's executor could reasonably be overturned is because of the fact that this idea of quasi-legislative or quasi-judicial, or in other words, not being central to the exercise of executive power, is, as Justice Scalia points out in his dissent to Morrison v. Olson, a rather nonsensical definition of executive power and of how to divide these independent agencies between the branches or of how to classify them therein. Justice Scalia makes note of the fact that to define something as mostly executive offers a bright line that is, in other words, impossible to define, and we don't believe that counsel for respondent will be able to do that here today either, presenting a line as to why the Federal Reserve can exercise core executive functions but also remain outside of the presidential control, which, as the court acknowledged in Sela, as the court stated first in Myers, and as the very wording of the Constitution explains, is the default.
So I just have a question about Franklin versus Massachusetts and how your rule would square with that case. So if we say that the Federal Reserve is wielding executive power, does that mean then that we need to overturn Franklin, because in Franklin we said that the president that the APA did not apply to presidential action? Is the Federal Reserve, as an extension of the president, what would happen in a situation where the APA where there's an APA action against an action by the Federal Reserve that's at the direct behest of the president? Under your rule, since the Federal Reserve chair is wielding executive power, would Franklin's clear statement rule apply or no?
Your Honor, while I'm less familiar with the specific implications of Franklin, my facial understanding would be that this wouldn't require us to overrule Franklin v. Massachusetts, nor would it be in any way a direct problem, mainly because of the fact that even if you don't adopt our ruling in favor of Petitioner, the Federal Reserve would still be classified, as I believe my co-counsel on the respondent side would likely acknowledge, to be wielding executive power. And so that question that you ask would be implicated regardless of a ruling in favor of Petitioner. And so we don't believe that, in regards to your question, overruling Franklin v. Massachusetts is relevant in either aspect, because of the fact that even in the current status quo, the court is able to reconcile those two ideas. And so consequently,
I recognize that you're not asking for Humphrey's executor to be overturned, but you're still asking for a large departure of settled practice over a long period of time. I guess, why shouldn't we give some due consideration to the reliance interest that a lot of interests around the country have placed into this, and just adhere to the tradition of how we've treated the chairperson of the Fed for a long time now?
Two reasons, Your Honor. First and foremost, because our Constitution is not based upon practicality, rather it is based upon the constitutional intent that the founders have. But secondarily, because we don't believe that the reliance interest we have in continuing the doctrine of Humphrey's executor is in fact particularly harmful to the current administration or to the continued functioning of the Federal Reserve. If we were to do away with this idea of, as Humphrey itself explains itself, things that are not part of the executive branch or not wielding significant executive power being considered a definition of drawing the line between an executive agency or a non-executive agency, we don't believe that this implicates a variety of other governmental agencies, as A, the definition is nonsensical and would confuse things as it currently is, and B, the vast majority of government agencies that could potentially be called into question do in fact have an easy, obvious answer, that being they wield executive power and thus are part of the executive branch, because of the fact that, as Sela defines the executive power, it is those rulemaking, enforcement, and adjudicatory authority functions that constitute the exercise of the president's ability to enforce the law. And so the reliance interests, we don't believe, would be significant nor particularly pragmatically harmful. However, even aside from this question, Your Honor, we think that the simple answer on the most facial or foundational level is, in fact, that the Constitution dictates all of the presidential executive power shall be vested in the president, who is the chief executive. We would thus briefly...
Counsel, I just had one follow-up thing, because the Constitution does seem to allow, the legislature to have a lot of say in what the, executive does. They could impose a lot of regulations on the Fed. They could get rid of the Fed tomorrow. They're also, in charge of even, confirming the officers in the first instance. So it does seem that the Constitution contemplates a lot of ability for the legislature to involve itself in how the executive conducts itself. Why be so particular here when our constitutional system seems to allow additional layers of, want to call it accountability or what have you, upon the way that the executive goes about its business?
Because, Your Honor, the ability of Congress to expand or to narrow the limits of the executive power is well understood, but the ability of Congress to take parts of the executive power and remove them from the president is not. And that's the distinction that we would draw here today. While Congress does in fact have the ability to expand or to limit what constitutes a part of the executive power through the creation of agencies, they don't have the ability to take the president's power to enforce the law and give it to someone else who is not answerable to the president as an extension of himself. Thank you.
Mr. Chief Justice, may I proceed?
Yes, please do.
Thank you, Mr. Chief Justice, Honorable Associate Justices, and may it please the Court. My name is Xander Yoder, and I will address the injunction issue. Your Honors, two wrongs do not make a right. As Justice Barrett put it in Trump v. Casa, when a court concludes that the executive branch has acted unlawfully, the answer is not for the court to exceed its power to. It is this basic principle that punishment must not only be dispensed, but dispensed correctly, that underlies our courts and our system of governance. Without it, what we claim to be justice is no true justice at all. It is because courts lack the power to force the president to perform his executive acts that we ask your honors to overturn. To assert presidential immunity from judicial compellence, we submit to the court two facts. First, that the president has a privileged status relative to his subordinates, and second, that he possesses a status co-equal to that of the legislative branch. To the first, the President of the United States occupies a unique position under the Constitution. That's particularly true when it comes to his importance relative to his subordinates. The chief executive receives far more protection from judicial action than, for example, a cabinet secretary. Your honors recognize this in Nixon v. Fitzgerald and in Harlow v. Fitzgerald, as cited by Justice Scalia and Franklin, the latter of which noted that suits against other officials, including presidential aides, generally do not voke separation of powers considerations to the same extent as suits against the president himself. Thus, the president must be treated differently than his subordinates when it comes to separation of powers concerns. However, if we allowed the judiciary to force the president to perform his ministerial duties, he would be receiving no more protection than his weaker subordinates, a state of affairs that this court has emphatically disclaimed. Nixon and Harlow held that the president occupies a more privileged position than his subordinate officials, but siding with the respondent in this case would make his
counsel, it is it your position that no court could reinstate a removed officer? I mean, I tell me if I'm wrong, but isn't it possible through mandamus or remedies at law for reinstatement to happen?
In general, yes, Your Honor, but in the case of the president himself, no. While it is possible to accomplish that remedy for lower executive officials and their decisions, the fact is that the power or the article or the person in which the chief executive power is vested occupies a more deferential and more privileged position than his subordinates do, per this court's holdings in Nixon and in Harlow. As such, we think that there's no legal justification for violating the separation of powers doctrine in this case, as doing so would make it so that the president's protections are equal to that of his subordinates. Under Mississippi v. Johnson...
So, counsel, I'm sensing a little bit of a dissonance between what you're arguing and your co-counsel is arguing. Your co-counsel seems to be saying that all of these officers in the executive branch are the same. And you're arguing that the president is different for various reasons. The president and these other officers are all wielding the same executive power. And if that's true, that's what your co-counsel said. If that's true, then shouldn't courts be able to apply the same remedies to each of them?
No, Your Honor, because there's a difference between power and status. And the fact is that the status of the president, as affirmed in Nixon and Harlow, is different from the status of his lower executive officials. To allow the president himself to be forced to perform his ministerial duties would create a situation in which the judiciary is able to effectively subordinate the executive to.
But are we actually requiring him to perform a ministerial duty here? I mean, it seems like we could just simply enjoin the Federal Reserve and say you have to keep paying, this particular individual and keep this person on your payroll and keep this person in the office. We wouldn't have to say anything to the president.
That's one option, Your Honor, and it was one that was considered by the D.C. Circuit in Swan v. Clinton when they faced a somewhat similar situation as regards reinstatement and removal. But we would request that this court, like the D.C. Circuit in Swan v. Clinton, reject that measure because, as they themselves noted, it's inherently flawed, as it's still subject to the president's contradiction and making a de facto reinstatement by ordering everyone around the officer in question to treat the officer in question as if he were in fact still in his position is an unsustainable solution. In most
But
cases,
your position there is not that we can't do that, that we don't have the power to do that. It's just that we shouldn't because it would cause practical difficulties for I mean, I guess enforcement and the people around. I mean, is that your position?
that is one of the reasons we think that position is a bad one, Your Honor, but there are others as well. Take, for example, the other objections that one could raise to the Swan v. Clinton exception, or rather the Swan v. Clinton remedy, if you will. While it was decided on other grounds, it's worth noting that Swan and the D.C. Circuit in that case thought that the remedy was a poor one, not just because of practical difficulties, but also because it's a clear attempt to contravene the idea that the president is a president's orders can be effectively compelled of him. Think about it this way. In the Swan v. Clinton remedy, the court is not really reinstating Chair Crosby. What they're doing is making him a sort of de facto quasi-legitimate officer when there are two contradictory branches in question. However, under the legal remedy that the respondents ought to essentially promulgate, it would be not just de facto, but a de jure solution, which we believe is unconstitutional. So we don't believe a de facto is a solution is either appropriate or practical. And as such,
Counsel, I wanted to just quickly return to your point about how basically siding with the president's position here would uphold the separation of powers. I'm struggling with what the dissenting judge, our colleague below, said about how it's time for the courts to remain silent. Because what I see here is if, say, your counsel is wrong and that we do find that, like, okay, president shouldn't have been able to remove Mr. Crosby, but you're asking, too bad, so sad, you don't have a way to reinstate. What I see then is the legislature cannot violate separation of powers. That is, they can't put removal protections on officers because then the president can remove them. But the president can violate separation of powers by ignoring, lawful removal presentations simply because we don't have a remedy to rectify that. So I guess how does that position uphold the separation of powers? Because I feel like we're put in a little bit of a quandary here where somebody's got to give, and it doesn't seem to help anyone. The powers seem very muddled as a result of your position.
And we think that's understandable, Your Honor. That's why we don't contend that the only possible solution to the current dilemma is this court. As Justice Scalia pointed out in his concurrence to Franklin v. Massachusetts, citing Nixon v. Fitzgerald, the Nixon court upheld, or rather found, a series and a whole list of other potential remedies, some of which involve the political process, for example, that are able to hold the president accountable without direct interference or compellence, in this case, of course, by this court. And so we think that while it's certainly laudable that the judiciary seeks to uphold the law and should do so wherever it can, there are also limits beyond which the judiciary cannot pass. As Justice Barrett wrote in Casa, simply because the executive has overstepped his bounds does not also mean that the judiciary should as well. That means, in fact, leads us to, I suppose, in response to your question, to the fundamental difference or the fundamental similarity between the executive and the legislative branch. To rule in the respondent's favor would create a fundamental inequality between the executive and legislative branches, as the checks and balances that apply to the president would not so greatly be applied to the legislative branch. The United States has three branches: executive, legislative, and judicial. None of them is supreme, and each applies checks and balances upon the other two, but those checks are applied equally. For example, take one of the legislatures.
So let's say that the fired chair has the legal right. What's your proposed remedy? Did I hear that it's the political process?
That's one of the proposed remedies that Justice Scalia cites in his concurrence to Franklin v. Massachusetts, Your Honor. He identifies a list set forward by Nixon v. Fitzgerald, which includes multiple different remedies, but one of them is the political process, including elections and impeachment.
What are your others? So, like, in other words, when I hear that, for this fired chairman, that just means there's no remedy, right? They've been fired illegally, and hopefully the law changes at some point. So is there any other kind of remedy?
There's no remedy from the judiciary, Your Honor, short of a declaratory judgment, which we don't hold would violate separation of powers. But we do believe that the political process is the main means by which the founders intended to hold the president accountable. As such, we believe that the separation of powers doctrine is not always convenient, but it is absolutely necessary. Thank you.
Thank you, counsel. We'll hear from respondent.
Yes, Your Honor. May I proceed?
Yes, you may.
Mr. Chief Justice, Honorable Associate Justices, and may it please the court. My name is Kean. My co-counsel, Mr. Joshua Wang, and I represent Mr. Mark Crosby, the respondent in this case. My co-counsel will address the injunction issue, and I will address the Article 2 issue. The framers of the Constitution feared a nation where the president controlled every aspect of everyday life. Financial policy, and by extension the Federal Reserve, is perhaps the epitome of the government's control over the day-to-day dealings of Americans. The president's short-term, popularity-focused policymaking must be entirely separated from this control. For this reason, we ask this court to affirm the decision of the lower court. To that end, we offer two lines of argumentation. First, that the Federal Reserve can be protected from presidential removal, and second, that it must be protected. To the first point, that the Federal Reserve can be protected. This court has significant precedent that agencies like the Federal Reserve may have removal protections. This concept was first put forward in the case of Humphrey's Executor versus United States, where this court recognized the power of Congress to establish such protections. Now, I understand that the petitioner argues that Humphrey's Executor was wrongly decided, but we must understand Humphrey's Executor in the context of what later court decisions decided it actually meant. Humphrey's Executor originally read, quote, Congress, in creating quasi-legislative or quasi-judicial agencies to require them to act independently of executive control, cannot well be doubted. And that authority includes power to forbid their removal except for cause in the meantime, end quote. Humphreys laid the groundwork for the traditional independent executive agency. And while we contend that
counsel,
the federal...
I mean, I guess I take that point, but it seems like seal of law dealt a pretty deadly blow to Humphreys as far as extending it to other cases that aren't factually identical. So how do you deal with that?
I would disagree, Your Honor. In fact, for the rest of this, I would actually like to contend the Federal Reserve falls under the standard not of Humphrey's Executor, but actually set forth in SELA. In SELA, the court established that removal protections were constitutional for multi-member expert agencies that do not wield substantial executive power. And even under this incredibly narrow exception, the Federal Reserve deserves protection. It is run by a nonpartisan multi-member board, and contrary to common belief, exercises a very limited part of the executive power. The Federal Reserve's primary power, according to the Cornell Law Review, is the ability to set interest rates. Even its most executive power is very limited in its regulatory function. The Federal Reserve...
So, counsel, can you maybe just back up a little bit and define for us what you mean by executive power, and then also square that definition with our decision in Boucher?
Yes, Your Honor. To the idea of defining executive power, we must first differentiate it from executive function. While we believe that the Federal Reserve does exercise executive function, that isn't the standard that's set forth by this court in deciding whether or not an agency should be controlled by the president. Rather, it's the amount of executive power that a particular agency exercises that determines whether or not for-cause removal standards are valid. In this case, the differentiation between executive function and executive power comes into scrutiny when we consider its regulatory function, or rather, how much it actually enforces its rule or law upon the private sector. And we actually see that that regulatory function is relatively narrow. The Federal Reserve sets a targets fund rate, the interest rate that banks use when loaning to each other, but it does not enforce that rate. Nor does it punish any other bank that does not comply. Rather, it indirectly seeks to align private rates with its goal, both by controlling its own rate that it charges private banks and by manipulating the supply of money itself. The reason the Federal Reserve operates in this indirect way is because it isn't a novel system, but rather one that's been happening for a very long time. More specifically, it follows in the distinct historical tradition of the first and second banks of the United States, which the founders of our country and inventors of the separation of powers allowed to stand with removal protections.
Counsel, I just want to clarify some of the contours of your position. You just described a substantial amount of the way that the Federal Reserve functions in terms of the power it wields, but in SELA, we pointed also about the number of officers, I guess you could say, who run the agency. So I just want to understand, I get the contours of your argument correct. Are you saying that even if the Fed only had one chairperson, that the nature of the authority that the Fed wields would still permit the removal protection, or is it a both? That it
No,
needs to
Your
be
Honor.
multi-member and not entirely substantially executive?
Yes, Your Honor. I would contend that it's a compound standard, that it has to be multi-member and expert, as the Federal Reserve Board is, and it must exercise a small or limited amount of the executive power. The Federal
Can
Reserve
you
meets both
justify then for
requirements.
me where the Constitution says that the executive can remove this type of executive officer wielding executive power if they're standing alone, but if there's three of them next to each other, that suddenly they're no longer removable? Because the Constitution doesn't seem to contemplate groups of officers and singular officers. It just talks about officers in the abstract. So how can we root that in the Constitution?
Yes, Your Honor. Unfortunately, we can't find that text in the Constitution. Where we can find it is in this court's precedent. And I would turn you not just to the idea of how many members run the Federal Reserve, but also to the powers it exercises. Single member agencies that exercise executive power have consistently been held to be unconstitutional by this court. The reason why is because they cannot be held accountable by the people. But as stated in SELA, among other statements of this court's precedent, this can be allowed and this standard can be set forth because there are other individuals on the board to keep the chairman in check, thus achieving a situation where they can be held accountable to the people, whereas a single member agency cannot.
But counsel, so I guess I'm still struggling with if you're admitting that the Federal Reserve is wielding executive power, then I mean, SELA law says, executive power, all of it is vested in the president. So how does the president not have removal authority over someone who's wielding his power?
Yes, Your Honor, I'd like to clarify my continuing here. It is not that the Federal Reserve exercises executive power, but rather that for simplicity's sake, it is constituted as exercising executive function. That is, it is part of.
What type of power does the Federal Reserve exercise then?
I would contend that the power the Federal Reserve exercises is actually most likened to the private industry rather than any public branch of government. They exercise power in an indirect way, much like a very large corporation might, by using their influence over currency and their ability to hold or sell particular shares to the effect that their regulations come into effect. But the vast majority of the time, they do not directly impose their will on the private sector.
But they are able to, adopt policies and use the force of government to effectuate those policies. No private titan of industry can do that, right?
Yes, Your Honor. And in those particular circumstances, I contend those are very limited and would fall under the SELA standard of not wielding substantial executive power. The vast majority of the functions of the
But then I
Fed
guess you're
are
still
not
admitting
executive.
though that they're wielding some, maybe not a substantial amount, but some, right?
Yes, Your Honor.
Okay. And if that's true, then under SELA law, shouldn't the president be the one who has hiring and firing authority over them if they're wielding his power?
I would like to clarify, Your Honor, that under both a decision for the petitioner and for the respondent, the president is still the individual who the buck stops with. In fact, in Morrison versus Olson, this court wrote that for-cause removal protections actually provided the executive with, quote, substantial ability to ensure that laws are faithfully executed. So the ability of the executive to hold in check a agency exercising his power is still in place, even with a ruling for respondent. The difference here is that at-will removal must be reserved only to agencies that are substantially executive, and those that are designed to be independent and do not wield substantial executive power, this court has held, may be exempt from at-will removal while still having that check for the people and on the government, rather on the president's power, where they can continue to hold that board accountable if they were to step out of line and cease to faithfully execute the laws, which it is the president's job to ensure that they continue to do so.
Counsel,
Moving away from
you discussed the accountability to the people. It seems like the people's accountability has been limited to only once an officer does something worthy of for-cause removal, that they have no other way seemingly to, voice their disfavor, i.e., under your friends on the other side perspective, if they didn't like the way that like executive officers in the Fed were managing their day-to-day, they could elect a president who could campaign on changing that. It seems like, I want to pose a similar question as I asked your friends about the separation of powers concerns here. It seems like your friends offer a much more democratically accountable option here. So how does your position, which removes democratic accountability, better uphold separation of powers?
I would disagree with your principle, Your Honor, that my position undermines democratic accountability at all. To look to that, we actually have to look to the Take Care Clause, which defines what executive power was meant to do in the first place. That is, ensure that laws are faithfully executed. Those are the laws passed by Congress, who are duly enacted by the individuals, by the people. They are elected. Thus, the duty of the Federal Reserve is to carry out the people's will through their elected representatives, and the executive's job is to ensure they are doing that properly. The moment the Federal Reserve ceases to do the people's will, that is Congress's will, the executive has full authority to hold them into account by the people through for-cause removal.
But counsel, your position, you're admitting that the legislature has hamstrung the executive's ability to ensure that his subordinate officers are taking care to uphold the laws faithfully. I understand that maybe at the extreme for-cause removal kicks in, but can't the president have some leeway in removing officers that are getting close to that line, or upholding that line in a different way than the executive would imagine? It seems like you've hamstrung the ability for the executive to use his power, his or her power.
I would contend that we haven't, Your Honor, because again, the purpose of the executive is to ensure that the laws are executed, not directly in position with how the president wants them executed, but rather in how Congress wants them executed. That's the purpose of the executive power, and it's upheld in the current system, which is why we ask that this court affirms. Thank you.
Thank you, counsel.
Permission to proceed, Your Honor.
Granted.
Thank you, Your Honor. Mr. Chief Justice, Honorable Associate Justices, and may it please the court. My name is Joshua Wang, and I'll be addressing the reinstatement issue. The petitioners would contend that even though the president unjustly and illegally fired Crosby, the only compensation that can be given is back pay, which doesn't affect or come from the president's pocket. That is not sufficient relief, and it also doesn't discourage the president from violating the law in the future. Crosby deserves full relief, according to his legal right to his seat, and it is a responsibility of this court to use the power that it holds to set right what the president should never have interfered in. This court should affirm the decision of the lower court and enjoin the president to reinstate Crosby. Now, we believe that an injunction or a mandamus are available remedies here. However, we will focus our argumentation on a writ of mandamus, a legal remedy used to compel a non-discretionary duty. We present two lines of argumentation to prove its application. First, that a writ of mandamus can be issued because the duty is ministerial. And second, that a writ of mandamus can be issued against the president because no one is above the law. Now, courts, having the power to order an officer of another branch, does carry a lot of control and a lot of potential for misuse and abuse. However, if there was no mechanism in place to compel an officer to do their duty, that would be equally, if not more, harmful. This is where a writ of mandamus comes in. While it does hold a lot of power, it's kept in check by the requirements that allow its use. The condition for a mandamus is to enforce a duty that involves no discretion, which this court outlined in the case of Kendall versus United States, ex rel. Stokes, on page 610. That a mandamus does not seek to direct or control the Postmaster General, but to enforce the performance of a mere ministerial act, which neither he...
So, sorry to interrupt, counsel. So, one of the requirements of mandamus is that there be no alternative avenue for relief. And it strikes me that if you're arguing that we can give an injunction, that seems like an alternative avenue for relief, whether we would agree with you on the merits or not. So, I mean, so how do you meet that mandamus requirement?
Of course, Your Honor. We would turn this court to the case of Kendall again, in which when we look to Kendall, when they ask for an injunction or when they ask for a mandamus, this court views it essentially as synonymous, because since the Judiciary Act of 1789, an injunction and a mandamus, if they are to achieve the same effect, can be used synonymously. But this comes from specifically Kendall on page 610, writing, "We do not think the proceedings in this case interferes in any respect, whatever, with the rights or duties of the executive, or that involves any conflict of powers between the executive and the judicial departments of the government." And we would...
I guess my point is, mandamus is supposed to be this extraordinary remedy that we courts basically never grant. Especially, and that's why there's the 3 Cheney requirements. And so if you can go to a court, and as you're arguing today, that court can potentially grant you an injunction if you prove that you have a legal right to it. How can we say that there's no alternate remedy, or there's no alternate avenue for relief?
The reason, Your Honor, is because to ask for an injunction would still be going to courts of law and enforcing a ministerial duty. Because if this court were to ask for an injunction, the reason they can ask for that injunction is because there is a ministerial duty that comes from the courts of law that the president is supposed to reinstate Crosby. And because it comes from courts of law, it also comes to a mandamus. Now,
But
we
you
agree
agree that the injunction as like the equitable remedy of injunction and mandamus are different things, right?
we agree, yes.
Yeah. So then, even I get what you're saying. It accomplishes the same thing, but we still distinguish between them because it goes to whether we even have the authority at all. So I guess I go back to why, if they are different things, and you can try to get the different thing of the injunction, then how can it be that you have no alternate remedy or alternate avenue for relief?
Of course, Your Honor. Let me clarify my position. The position of respondent is that to ask for an injunction or a mandamus are available remedies. But the reason they are available remedies is because to ask for an injunction is essentially the same as asking for a mandamus because you're enforcing a ministerial duty. Now, I do recognize the first part of your question, that injunction comes from courts of equity. However, we would contend that to ask for an injunction in the instant case wouldn't be to ask for an injunction from the courts of equity. Rather, be asking for an injunction from a ministerial duty, which comes from Swan versus Clinton, writing, in addition, we note that a request for an injunction based on the general federal question statute is essentially a request for a writ of mandamus in this context, where the injunction is sought to compel federal officers to perform a statutorily required ministerial duty. Meaning, we believe injunction and mandamus are both available here. However, to ask for an injunction would still be going to courts of law, which would then mean essentially you'd be asking for a
So
mandamus.
let's say we don't think a mandamus is available here because there is this alternative remedy of an injunction. Let's just totally focus on the injunction remedy, and talk about that for a second. How do you square pursuing an injunction remedy with our decision in Grupo Mexicano that says that you have to have something akin to an equitable cause of action back, at the founding? Are you pursuing anything like that with this type of injunction that the district court gave?
Yes, Your Honor. We would contend two responses here. The first of which is that to ask for an injunction, according to a statutorily required ministerial duty as defined within Swan, would still fall under a ministerial duty as defined in Kendall, which as this court defined is
Right,
when
but
an
so
officer.
this is an injunction, so we don't need a ministerial duty. So the question is just about the injunctive remedy and finding like an analog from the founding era. What founding era analogs do you have for enjoining the president?
Your Honor, there would be no synonymous analog, which is why exactly we asked this court to use a writ of mandamus here. Because
Okay, so you don't have an injunction. So the remedy of injunction it's not possible because there is no founding era analog.
in some sense, you're right, Your Honor. And the reason for that is because to ask for an injunction from courts of equity, because there is no analogous requirement or condition within the English courts of chancery, there would be no condition for courts of equity injunctions. However, to ask for an injunction, since the Judiciary Act of 1789 and the merger of law and equity, it would still be possible through a ministerial duty, which is, as the counsel for petitioners agree, there is a ministerial duty. But counsel for petitioners instead
So
choose.
what? So then, I guess my question is, so if it's a ministerial duty, there's no discretion at all involved. So you're asking us to put the. I mean, it's kind of it's odd to think of putting an officer who has been fired back in their position, and you're saying that is that all you're asking for is just reinstatement?
Yes, Your Honor. We would be asking for reinstatement because the wrong that was committed was Crosby was removed
Okay.
when illegally and unjustly.
Okay, so I mean, so you're still so you don't think that like the act of like rehiring a person involves discretion? I guess I'm just maybe you can clarify like what is a ministerial duty versus a discretionary duty?
Of course, Your Honor. We recognize the president has discretion when it comes to appointing officers and even removing them for cause. But when the president acts outside of his authority and removes a chair without cause that is outside of his authority and therefore is illegal and unjust, and according to the Kendall definition, that
Right,
would
but
constitute.
it's at least an act of discretion to do that, regardless of whether it's just or unjust. Putting someone in a position in a job or removing them from that job, that's an act of discretion, right?
In some sense, yes, but it's a discretionary duty that was completely illegal and not allowed, which makes it ministerial because the president has a duty to faithfully carry out the law, and by violating the law, they failed that duty. And I think the best way to explain this is by bringing this court to the case of Swan versus Clinton, where the facts are very similar to the facts of the instant case, where if a member of the National Credit Union Administration was unlawfully removed, a ministerial duty would be created. They write saying, Swan alleges that the president violated a duty to comply with removal restrictions contained in the NCUA statute. This duty, if it exists, is ministerial and not discretionary, for the president is bound to abide by the requirements of duly enacted and otherwise constitutional statutes.
Yeah, but those are like a particular statutory process that they had to follow. The act of hiring and firing someone, I think we both agree that is a discretionary act, right?
In general, yes, Your Honor. However, when it is done without the authority, it no longer becomes discretionary. It becomes a violation of the law and
But
therefore
why
becomes
does that change
ministerial.
whether it's ministerial or discretionary? Wouldn't that just say it would be an illegal discretionary act or a legal discretionary act if it's in compliance or non-compliance with the statute?
Your Honor, an illegal discretionary act would create a ministerial duty to create an action. And we would turn this court to Marbury versus Madison on page 170 when they write, it is not by the office of the person to whom the writ is directed, but the nature of the thing to be done, that the propriety or impropriety of issuing a mandamus is to be determined.
Counsel, I just want, before your time wraps up, I just want to clarify what is the thing that the president has a requirement to do at this moment in time that our order will read, we order under a writ of mandamus for the president to do X, that they have no discretion otherwise. What is that action that they have no discretion to do?
It'd be for Crosby to remain in his chair, which can only be enforced through a mandamus to reinstate Crosby. Thank you.
Thank you. Rebuttal?
Yes, Your Honor. My apologies. Give me one moment to make sure my timer is correct.
Sure.
All right, and I have permission to proceed, Your Honor.
Yes.
Thank you. Beginning with the first issue, that being the question of Article 2, we believe that counsel for respondent undersells, at the very least, the significant executive nature of the Federal Reserve. Counsel for respondent essentially contended that the primary mechanism by which the Federal Reserve influences the economy is a private one. However, as both page 3 of the Facts of the Record explain, as well as the Cornell Law Review article explains, that the Federal Reserve actually has...
That makes sense, and I see where you're going with that, counsel. Maybe you can help me understand how the Federal Reserve is not analogous to something like the Bank of the United States, which existed at the founding. They mentioned that in their argument.
Absolutely, Your Honor. Two things. First and foremost, the first and second banks of the United States had fundamentally different powers. Those banks could only engage in open market operations, whereas the Fed can also engage in stress capital testing and imposes fines for failing to meet those requirements, which are most certainly rulemaking, enforcement, and adjudication, which is the definition of the executive power per SILA. But secondarily, the board structure of the Federal Reserve is fundamentally different from the second bank. The second bank had 25 board members, 5 of whom were appointed by the president and also removable at will, whereas the Federal Reserve is nothing to the like. The other thing that we'd like to address regarding counsel for respondent's argument is the idea of the power of the Federal Reserve being a private one, but as LeBron v. National Railroad Passenger Corporation, as cited in the Cornell Law Review, explains, the court held that the National Railroad Passenger Corporation, known as Amtrak, was a part of the government and therefore subject to the Constitution. Despite language in Amtrak's charter disclaiming governmental status, the court reasoned that its structure and functions rendered Amtrak a federal agency for constitutional purposes. Thus, the idea of a private power being the central idea of the Federal Reserve, we believe is incorrect. Turning then briefly to address the idea of reinstatement or remedy for Chair Crosby's removal. We believe that the only argumentation that counsel for respondent really contended that interacted with my co-counsel's rationale was the idea that there isn't a problem with the violation of the separation of powers regarding a mandamus per Kendall. However, Kendall was both about a postmaster and not the president, and per
Counsel, I just
Mississippi
want to quickly get your perspective on what we had a lot of discussion with your friends about. Assuming that your friends asked for mandamus, do you contend whether or not there is an adequate remedy at law that would preclude mandamus?
Your Honor, we don't believe that there is an adequate remedy regarding Chair Crosby's desires. However, we do believe there is an adequate remedy for the wrong that Chair Crosby has incurred. Per Trump v. Casa, the standard of complete relief is what the court is able to provide, not what the plaintiff desires. And because back pay, we believe, is a sufficient remedy for the harm, while not exceeding the violation of separation of powers, we believe it's satisfactory.
Thank you, counsel. The case is now submitted. Congratulations, everyone.
Thank you, Your Honor.
Congratulations, great job.
Thank you all.